oral argument, although they will be decided in separate opinions. We will reconfigure the court following a brief recess in anticipation of our 10 o'clock case. For the consolidated arguments, each side has 20 minutes. Does either of you have any questions concerning our procedures?
No, sir.
All right, in that case, we're ready for argument in the consolidated cases. And run the podium down if you wish. Over on your right, there's a switch. Go ahead.
Thank you. And may I reserve 3 minutes for rebuttal, please?
That's up to you to keep track of.
Okay. May it please the court. I'm Adam Foster, number 35969 for the appellants Visa J Unity LLC and Aurora Alliance LLC.
Excuse
With
me. Okay, the timer's running now. Thank you.
Oh, thanks. And with me at council table is Stan Zislis, one of the owners of both entities. The question today for this court is really whether municipal officials can act with impunity in the context of municipal licensing. Are there any bounds on municipal officials in terms of abuse of discretion or exceeding their jurisdiction, or are they free to make licensing decisions that are driven by prejudice or perhaps even outright corruption? Similarly, are these types of licensing decisions bounded by constitutional guarantees of due process and equal protection under the law? Now, here, the more specific question is, can a court order a local licensing authority to follow its own rules and code? And there are 3 sources of rules and review that are important in this case. So one is the Aurora Licensing Authority implemented a purportedly objective points-based system to evaluate licensing applications. And when that system was presented to the public and the AMED rules were presented to the public, we would argue that at that point, it creates a set of standards and rules that the licensing authority must follow. Now, there's also a specific in the Visa J matter self-executing tiebreaker provision that's found in the Aurora Code section 6309. And that provision was supposed to be self-executing and not require an appeal by an applicant. But then there's a separate provision that's under Rule 802.11 that gives the applicant a right to appeal denial of a license under Rule 106. And importantly, that rule does not make a distinction between actual licensees and applicants. So an aggrieved licensee or an aggrieved applicant both have the same right to file an appeal under Rule 106. And we would certainly argue that that type of judicial review, in fact, is a requirement, whether it's in the rules or not, that the state constitution and the guarantee of due process and equal protection entitle an applicant to a non-arbitrary review of the application and a non-arbitrary exercise of discretion in reviewing the application. So that should be independent of any provision within the Aurora Code or the Aurora rules. Now, this court may be inclined to view this case as an anomaly because it involves marijuana licensing, and that's relatively new and in some circles still controversial. But we would argue that if the court adopts the city's position that applicants for licenses do not have any constitutional protections at all stemming from due process or equal protection, that it's hard to see why that would only apply to the marijuana context. Because if that's the state law rule that there's no protection of any kind, then it's hard to see how an other type of applicant for a different type of municipal license would be able to file a Section 1983 claim for money damages or to seek declaratory relief before this court.
But
Mr.
you've not-
Foster,
I'm sorry, go ahead.
I'm sorry. Didn't one of your clients bring a federal claim, a 1983 claim, and then withdraw it?
We did.
Can you share with us the concerns you had, the reasons for doing that?
It was because the Young decision from this court had come down in the meantime, and the Young holding was that money damages under Section 1983 are not available in the marijuana context. And so then at that point, frankly, we were concerned that we had a marijuana licensee and a government agency that's administering this marijuana licensing scheme, and that we were not going to receive favorable treatment in federal court. Whereas in Colorado, of course, there's a state law statute that says that Colorado courts, should apply in the marijuana context, should apply Colorado law. So we felt that we were more likely to get fair treatment in the state court, and if money damages were unavailable under 1983, there was no reason to be in the federal court.
So in terms of the anomaly, though, then you were the one who treated it as an anomaly and pulled out of the federal court because of that view.
That's accurate, Your Honor. And I guess the point that I was trying to emphasize was that in this context, of course, we're dealing with marijuana, but if the ruling is no rights of an applicant for a municipal license, then it's not clear at all that that would only apply to marijuana. It seems like that rule would either, since it's legal under state law and as part of the Constitution, would either apply to all classes of cases, including marijuana, or not.
Okay.
The only remedy sought in both of these cases was issuance of your two respective clients a license, correct?
That's partially correct, Your Honor. If you look at the prayer for relief in both of the complaints that were filed in both cases, there was certainly a request for a license. That's what we really wanted, and that's what we asked for. And we weren't necessarily asking that a license be taken away from another applicant. The preferred remedy was to issue a fifth license in the two wards. But the prayer for relief also goes on to ask for a finding that the defendants abused their discretion and exceeded their jurisdiction, as well as a holding that the defendant's appeal process did not comport with Colorado state constitutional guarantees of equal protection and due process, and then a determination of the parties' rights flowing from that holding under Rule 57. So then there was also an additional request for relief that would be such other relief as the court deems proper, that contemplated the court fashioning an appropriate remedy under Rule 57 if the court held that a license was not available.
What Colorado authority would empower the trial court, or us for that matter, to order Aurora either to take away a license that's been issued so your client could get a license, or to give your client a license in excess of the 4 licensee per ward limitation?
Yes, sir. So there are a couple ways to break that question down. The broad answer is that within Rule 57 and the accompanying declaratory judgment statute, courts have broad remedial authority to, first of all, to interpret a municipal ordinance in the first instance, and then to remedy a violation of rights. So that's one source of authority. A second source of authority is the appeal provision that we already talked about, 802.11, and the idea that if there's an applicant that appeals and is successful, there's got to be an appropriate remedy for that successful applicant. And so we have always argued that the idea that a fifth license could be issued for a finite period of time until a license is lost by attrition or otherwise is contemplated within the AMED zone rules, because it specifically provides for the appeal right of an applicant.
Well, why would the provision of an appeal right trump the absolute limitation on no more than 4 licenses per ward?
Well, the simple answer, Your Honor, is that we contend that because Section 6, Article 2 of the Colorado Constitution provides that there should be a remedy for every legally cognizable injury, that the court has the inherent right to fashion an appropriate remedy. Similarly, within these two code
Excuse me,
provisions.
So you're relying on the doctrine of inherent judicial power?
Partially, Your Honor, and the text of the code as well. The code, again, has two provisions that potentially seem like they can come up into conflict with each other. The one being the appellate right, the other being the cap of the number of licenses. And the code doesn't say, under no circumstances can the cap ever be exceeded if there's a successful appeal. And so we believe that, again, that tension can be resolved by issuing another license. And then the final point I'd like to make, Your Honor, is that with regard to Visa J, there's that specific tiebreaker provision within the code. So,
Does the tiebreaker provision, by its plain language, apply to a dispute between a licensee, a current license holder and an applicant, or only between two applicants?
So I think that question is, what is a current license holder? And as we have pointed out, there were conditional licenses that were issued that allowed an applicant to move on to further stages of the application process to eventually obtain a license to sell marijuana. But at the time that the tiebreaker should have been implemented with Mountain States Group, they did not have an actual license to sell marijuana. They had been granted a conditional license to move on to the next phase of the appeal process. And so they actually didn't receive a license to sell marijuana until November 13th, which was a month after the October 13th hearing, when the tie was brought to the attention of Aurora.
So counsel, is it your position then that a conditional licensee is the same as an applicant?
At that stage, yes. And we know that in part from the permanency of points provision, that the points were all up in play until the license was actually issued. The other point, though, that I think is important is that as of the April 2017 hearing, there were still not 4 actual licensees that were operating in Visa J's ward. And so in both wards, the Aurora Alliance ward and the Visa J ward, there have been applicants who either did not become operational or who had a license revoked. So it's not like, especially in the case of Visa J, if they had been granted a license at the April 2017 hearing and began operating, there would not have been more than 4 licensees operating in that ward at that time.
Couldn't
And-
Visa J just reapply when somebody else lost their license?
They could reapply in a different ward. They reapplied in they applied in the specific ward that they applied in, both because that ward was a desirable location and because they had leased a premises within that ward. So yes, they could apply if another license came up in another ward, but it wouldn't be the same as applying in the location that they had actually selected and leased in the ward.
Right, but you just said that somebody lost their license, that there weren't actually 4 licenses issued. Why didn't they just submit another application for one of those? I mean, I'm not
Yeah.
seeing those parties are part of this action.
Right. So with regard to 3LP, even though, and that was in Visa J's ward, even though 3LP had not built out their premises within the required time, and even though the Aurora Code, as revised, we believe obligated the city to take that license away from 3LP because they had not become operational within the required time, the city permitted 3LP to transfer that license to a different party. Similarly, in the Aurora Alliance ward, there was the Sweetleaf Company, the felons, who had their license revoked by the state licensing authority, and Aurora permitted the felons to sell their license to a different group rather than revoke it. So in those 2 specific wards, there were not other licenses that were open. Now, with that said, the cap of 24 licenses was not hit until sometime around the April 2017 hearing. So there was a time period where there were licenses available in other wards, but again, not where the applicants had actually leased their own premises. And then with regard to this due process question, and sorry, I beg your pardon. First of all, on the separation of powers question, I should point out that Article 3 of the Colorado Constitution specifically relates to state government agencies and the separation of power between state agencies. And the Peterson v. McNichols case stands for the proposition that a local agency is not necessarily required to the same constitutional protection as an agency of state government. But even when we're talking about licensing decisions by state government agencies, as we point out in the brief, there is still an element of judicial review. So even state licensing decisions aren't somehow off limits or areas where courts fear to tread. It's completely proper to review a state agency as well. And then with regard to due process, basically just a statutory or constitutional right for a non-arbitrary exercise of discretion in considering the application is all that's needed for due process. And again, here we have a set of licensing criteria that the city presented to the public and said, here's our way to pick the most qualified applicants, the best applicants. And both the public and the licensees, or applicants, pardon me, were entitled to rely on the agency following its own rules and administering its scheme. And so, again, I would contend that if the court were to hold that there can never be review by the court system of municipal licensing decisions, that it would just open up decisions to be made purely based on the whim of officials and, really for any or no reason, including outright corruption. And again, there's really no compelling interest to protect there in terms of unfettered discretion or impunity. There is a degree of discretion that's properly protected, but that still contemplates a proper level of judicial review.
What about protecting the city's interest in having no more than 4 licensees in a ward?
So I would agree that the city certainly can place a cap on the number of licenses in each ward, and that is within their power under the Colorado Constitution. However, here, there's not a finding that any specific harm would accrue if there were 5 licenses rather than 4. And so that lack of any particular harm, I think, needs to be balanced against the court's obligation to protect the constitutional rights of Colorado citizens and Colorado businesses. And so I would say that if one must yield a constitutional right to the non-arbitrary exercise of government power or an arbitrary cap of 4, then the arbitrary cap of 4 must yield. And if I may, I'd like to reserve the remainder of my time.
Certainly.
Thank you.
Good morning, Your Honors, and may it please the Court. My name is Carrie Johnson, and with me at council table is Craig Finger. Together, we represent the City of Aurora and the Aurora Marijuana Enforcement Division in both of these cases, the Aurora Alliance and Visa J appeals. As appellants noted, this case arises out of Aurora's rejection of both Visa J and Aurora Alliance's applications for retail marijuana establishment licenses. And while Visa J and Aurora Alliance have asserted claims for judicial review pursuant to 106A4 and declaratory judgment pursuant to Rule 57J, coupled with a variety of ancillary assertions regarding alleged constitutional violations, at its core, in this case, they seek only one remedy: for the court to compel Aurora to award each of them a retail marijuana establishment license. In making this request, VCJ and Aurora Alliance bring a litany of grievances with Aurora's process to the court's attention. But because they only seek this license, the case really turns on a single question. Can the judiciary compel Aurora to issue a retail marijuana establishment license to Aurora Alliance and to VCJ, particularly when there is no license available under the cap that was imposed by the Aurora City Council? In short, the answer to this question is no. And this is based, of course, on the constitutional principles of separation of powers, as well as a string of cases at the Colorado Supreme Court in which it is held that licensing is not a proper function for the judiciary. And regardless, even if the court could otherwise impose such a remedy on the city, there simply was no constitutional violation. VCJ and Aurora Alliance simply do not have due process rights as applicants for a license. Now today, most of appellants' issues that they've raised on appeal are not based on issues that were actually decided by the trial court. So I don't intend to address in each and every one of their assertions that they have raised. That being said, I just want to focus primarily on why appellants' requested relief is unavailable and why that reality compelled the dismissal of their claims, as the trial court found in both the Aurora Alliance case and the VCJ case. I will then briefly address VCJ's motion to amend its complaint to add new claims, which includes that due process claim. As an initial matter, however, I think it is noteworthy that VCJ stated their stated issues on appeal are not based upon appealable issues actually decided by the trial court, nor does VCJ identify specific error with respect to each of the trial court's actually appealable orders. Case law is clear that an appellant must inform the court both as to the specific errors relied upon and as to the grounds, the supporting facts, and the authorities therefore. In reality, though, here, VCJ's asserted issues, for example, whether the court erred in holding that Aurora could ignore provisions of its code, simply do not actually tie into any orders. The court never held any such thing. The court was focused in both cases on the fact that the remedy that they sought was not available. And accordingly, the case is moot. There is nothing to decide if it would not provide them any relief that they're actually requesting.
So let me ask you this, Ms. Johnson. So they make the point of saying where the city provides a right, there's got to be a remedy, if I understand them correctly, and that the city is providing them with no remedy. And your point, if I understand you correctly, is that because they seek only to compel a license, that they try to put themselves in that box where there is no license to be provided to them in this context and in this scenario. Is that right?
That is correct.
So exploring sort of the scope of the where there's a right, there's got to be a remedy. If there were, and this is a hypothetical now because I'm trying to figure out the scope, all right. If there was an equal protection claim that we didn't get the license because of blatantly racially discriminatory practices, what would the remedy be then for them?
Well, first of all, Your Honor, of course it is worth noting that there is no such equal protection claim. That was not even raised until a motion to amend, which was denied within the discretion of the trial court. Secondly, because that's not an issue here, I mean, of course it's a difficult hypothetical, but I think marijuana is a unique industry in the state of Colorado. It's a unique industry in the country. It remains illegal at the federal level. And so while that would be unfortunate, it's not supported by the record, but if that were supportable, of course that would be unfortunate. But the reality is, ordinarily, for that type of allegation and that type of claim, what you would seek is monetary damages under a federal 1983 claim. The state of Colorado has not elected to enact a statutory scheme akin to a federal 1983 claim which provides monetary damages. That simply doesn't exist at the state of Colorado level. And as my opposing counsel even said, those 1983 claims have been held to not be applicable to the marijuana industry because of the reality that it remains criminal at the federal level. If and when that ever changes and appellants such as Visa J or Aurora Alliance could have those types of claims heard in federal court, that would be the obvious remedy to the extent they could prove that claim.
But until then, because of the uniqueness of the marijuana industry, in the hypothetical that I gave you, there wouldn't be a remedy then.
Yes, I believe that's correct, Your Honor. I think it's unfortunate. I'm not suggesting that it's not, but that is the reality. In this instance, the constitutional provision that the voters of the state of Colorado passed actually provided constitutional rights not to license holders, not to the marijuana retailers themselves, but rather to the cities, to the municipalities to limit the sale of marijuana in their own borders. And that constitutional provision specifically says that includes the number of retail marijuana establishments that may exist. So to the extent there are any real constitutional rights at play here, it would actually be the city of Aurora's in being authorized to regulate this industry.
Okay.
So I think it is worth discussing as we move forward a few of the key factual underpinnings of this case, including some of the allegations that my opposing counsel raised in his argument. As just discussed, of course, it was Constitutional Article 18, Section 16 that the voters passed that did legalize marijuana in the state of Colorado in 2014, but also did give the cities the right to regulate it within their borders. As the court has already noted, the Aurora City Council then elected to cap the number of establishments by only allowing 4 licenses per city council ward and only allowing a total of 24 licenses. In doing so, it also established the Aurora Marijuana Enforcement Division, which was tasked with assessing the applications, reviewing the applications, and awarding the licenses. Now, counsel for Visa J and Aurora Alliance contends that the city had only actually awarded conditional licenses to each of the applicants that were the recipients. That is a distinction without a difference that is simply colloquial in nature. In reality, those awards were final awards. The only question that gives rise to the conditional distinction is whether the applicants who had received those licenses, so at this time the licensees, had actually fulfilled the requirements that they had promised that they would do within their applications. So the only question was whether they were authorized to actually open. So the distinction that counsel is making is actually doesn't exist, and in fact, all the licenses that were available in the wards in which Visa J and Aurora Alliance applied were in fact granted and are now taken.
If there was a vacancy, would the separation of powers doctrine prevent the trial court or us from ordering that the open license be given to one of the appellants?
Yes, Your Honor. The separation of powers doctrine and the line of cases that the Supreme Court has issued over the years suggests that the court simply cannot act as a licensing authority. The appellants are correct in the sense that the court could order Aurora to follow its own rules, and certainly Aurora would and should consider the application of Visa J and Aurora Alliance, but the case law is pretty clear that the courts cannot compel Aurora to issue them a license.
Even if the record was beyond dispute that they were entitled to the 4th license, we still couldn't order Aurora to give them the 4th license?
I think in that circumstance, the result would be that they would likely get the 4th license. I believe that the court in that instance could order Aurora to go back and issue licenses and follow the regulations with respect to the issuance of licenses, of course, but then you're saying that there isn't that in that circumstance there would be a license available, so it would compel the result that Aurora would review its own law in that instance and likely issue the license.
Can Aurora, though, avoid ever having to issue a license to either of these applicants if current licensees just transfer to other people?
Yes, I believe that is the case, and that is what happened with the Sweet Leaf license, because the state of Colorado, the state marijuana enforcement division, actually decided that Sweet Leaf, though it had had engaged in criminal activity and had its license revoked, it was entitled to sell those licenses. So Aurora was simply following the state of Colorado's, its suit with the state of Colorado. So a couple of other issues worth correcting with respect to the factual issues is, for instance, the permanency of point provision. They raised that with respect to the argument that the licensees were actually still only applicants after Aurora had awarded the so-called conditional licenses. Those provisional points provisions do not speak to the fact that there is no permanence in the actual award of the license. What those provisions speak to is, again, simply the failure to adhere to what they've set forth in their own application. In that instance, Aurora could have revoked the license, although, again, that would have to follow certain due process requirements, because in that instance, an applicant that has been issued a license has acquired a due process interest. Turning to the question at hand, whether the judiciary lacks the power to order Aurora to issue appellants a license, of course, the separation of powers doctrine is set forth in Article 3 of the Colorado Constitution. And appellees suggest that it does not apply to cities. That is simply not the case. I mean, courts have repeatedly applied separation of powers principles in the context of cities, and especially, even if you put aside the fact that Aurora is a city, to licensing authorities. Licensing authorities are typically granted that authority by the legislative branch, as and here they were actually granted it by the Constitution, but then further by the legislative branch based on the state of Colorado's legislatures setting forth the legislation, passing legislation to carry out the will of the voters. So there are certainly numerous cases that apply it in the context of both municipalities and licensing agencies. And with respect to Rule 57, counsel for VSJ and Aurora Alliance argues that that Rule 57 provides this court with the ability to override those separation of powers principles and simply apply some sort of relief as deemed just and proper. In fact, case law says that Rule 57 is not meant for that purpose when it comes to judicial review of governmental action. That is what a 106 action is for. Rule 57 is limited to facial challenges to the constitutionality of statutory and regulatory authority. Here, there is no challenge to Aurora's passage of a law that says that there can be no more than 24 licenses issued in its city, or 4 licenses per ward. So even if the court were otherwise able to fashion broad relief pursuant to Rule 57 in the context of administrative review, it is not available. Less critical to the actual outcome at the trial court level, which was really all based on the separation of powers principles, but still certainly relevant to the issues in this case, is the question of whether the appellants had due process rights that Aurora could have violated. Case law is clear, and there's a variety of Supreme Court and Court of Appeals case law that says that applicants for a license do not have due process protections. And so there must be, of course, a vested property interest before due process can be violated. In the instant case, there is no dispute that neither VSJ nor Aurora Alliance ever acquired an actual license, which means they never acquired an actual property interest. Because of that, even if the court were otherwise able to compel Aurora to issue a license, it simply would not be appropriate here because there are no due process claims or violations at issue.
So in what context would they have a remedy, and what would their remedy be? Because you're saying that they don't have it, that there's a separation of powers argument. Can you give me an example where they would have a remedy and what it would be?
Certainly, Your Honor. One example would be MSG, the applicant that actually did receive a license, where Aurora acknowledges that that receipt was in error because they should have tied based on the scoring with Visa J. If Aurora had granted them a license and then recognized the error and then gone back to MSG and said, we have to revoke your license, that would give rise to due property rights. So if we were to revoke a license that was issued to a recipient such as MSG, or if the tables had turned to Visa J, we wouldn't be entitled to simply revoke that license without affording due process. That would be true if Visa J had been the recipient, instead of MSG.
But of course, Visa J was not the recipient. So in their situation, is there a situation where they would ever have a remedy, and what would it be?
Yes, if not all of the licenses had been issued in the ward in which they applied, there would be a remedy in that circumstance. And the remedy likely would be the issuance of a fourth license. For instance, at the time of the initial application process, I believe it was Ward 6, there were only 2 applicants. So both applicants in Ward 6 received a license. If a third applicant, if Visa J had applied in that, in that ward and been improperly denied a license, then the remedy would have been to provide them a license.
But even in that situation, the remedy would belong only to the city. The court could not force the city to issue the license.
That's correct, Your Honor. In our view, the Supreme Court cases, the line of cases that speak to the power of a licensing agency to, the unique power of those licensing agencies to actually provide licenses simply does not extend to the court. And so the court would not be able to compel an issuance of a license in that instance. Now, again, what the court likely would do is perhaps, if the circumstances warranted it, declare the action arbitrary and capricious under Rule 106, remand back to the agency for further review. And in all likelihood, the outcome would be the issuance of a license.
In personnel matters, can't we order that an employee wrongfully terminated by a municipality or county or state be reinstated?
Yes, I believe that is true, Your Honor, although, again, that's not the licensing context. So it's a unique...
Is the licensing context different?
Yes, because the licensing context, Your Honor, is uniquely within the, in this case, the executive authority of the city or whatever the licensing agency may be. In the marijuana context, there have, of course, not been a lot of cases on these subjects, but the cases that have been issued have concluded that, for instance, in the Colorado Health Consultants v. City and County of Denver case, the court concluded, and I actually believe Judge Fryer was the author of that decision, that a licensee does not have a due process right in the renewal of a license. So that's, of course, even one step further than what we're talking about here, because that was a licensee that was operating, went to get its license renewed, and the court held that there was no due process right to the renewal of that license. So here we aren't even speaking about a group that had been operational. We're speaking only about a group that had applied for a license. Now, to briefly address the Rule 106A4 claim, I will only note, because I'm running out of time, that that there has been no cited error within the court's ruling, nor has there been any citation to the actual record itself by appellants as to what error they perceive with respect to the 106A4 claim. And with that, Your Honor, I would rest on our briefs, and thank you for your time.
So with regard to the Rule 57 issue, Rule 57 is not just for a facial constitutional challenge. Review of the record would be adequate for a facial constitutional challenge because it would only be looking at the text of a statute or a constitutional provision. In fact, requests for declaratory relief presuppose the existence of a trial forum rather than a review proceeding, and the evidence that can be presented to justify declaratory relief is not limited to the record made in the administrative proceedings. That's the Cinco Inc. case cited in the brief. And so Rule 57 proceedings are uniquely appropriate in cases like this where there are allegations of prejudice or corruption, or that an agency did not follow its own rules for improper reasons. So, that's why Rule 57 is necessary in this case versus 106.
Let's assume that there are other applicants out there for whom the city also misscored the applications. I mean, is it your position that we could grant relief not just to your client creating a 5th license, but to somebody else creating a 6th and somebody else creating a 7th, as long as the record was sufficiently clear that the city had mishandled the application process?
If the circumstances warranted that kind of exercise of the court's remedial or authority to grant remedial relief under Rule 57, and if the applicants applied for judicial relief in time, yes.
So then the 4 license per ward cap would become meaningless?
It would be meaningful to
Become subordinate to the exercise of judicial power?
True. Correct.
Isn't that what separation of powers is all about?
So, again, Your Honor, though, in all of the separation of powers cases, at the state level, it talks about the necessary role of the judiciary and the necessity of judicial review. So again, if it's an arbitrary cap or a state constitutional right, the arbitrary cap has to fall. The Constitution must prevail.
Well, what's the basis for saying that 4 per ward is arbitrary? I mean, was there some kind of a factual record made that the city administrators just pulled the number out of the air?
There was no factual record at the city council level that it was based on anything other than a number the city council liked, and there was testimony about that at the trial court in the April hearing.
Okay.
Thank you, Your Honor.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel in this case are excused. The bailiff will announce a brief recess, and the court will resume with different configuration at 10 o'clock for our 3rd case.
All rise. The court will now be in recess.
Welcome to Division 3 of the Court of Appeals. If you were here for the first two cases that were argued, Judge Webb, who was presiding then, noted that we were going to reconfigure the division, the panel, which we have done. So to my left is Judge Rebecca Freyre. I'm Gilbert Roman. I'll be presiding, and we're pleased to have Judge Gail Miller, a senior judge, joining us today. Before we begin, I want to remind everybody in the courtroom that if you have anything that would make noise or go off or beep, please turn that off now. And we gave you both the protocols and procedures of the court, and I see some familiar faces as well. Do you have any questions before we begin?
No, Your Honor.
No, Your Honor.
Okay. Then, with that, I'll officially call the case, Marriage of Ramirez, case number 2018-CA0147, and we are ready to proceed.
May it please the court, my name is Ann Hoyland Gill. My registration number is 14610. I'm appearing on behalf of Ricardo Ramirez, the appellant in this case. The panel submitted two questions to be addressed in this argument. I'd like to go straight to those. The first question is whether the caption of the 60B motion was sufficient to put the trial court on notice. I have not found any authority directly on point as to that question. I submit to you that the caption, which says it's a motion pursuant to 60B 4 and 5, should have alerted the trial court that that was the way that the motion was being presented and argued to the court. Your second question is whether there was anything in the body of the motion that supports that this motion should have been analyzed under B4 and 5 time limitations. The motion presented 4 issues, and I submit to you that they were postured all as either 4 or 5 reasons for setting aside the judgment, which should have triggered the time limitation that was the trial court relied on in denying this motion. The first issue that was presented went to the equity of the separation agreement awarding all marital property to the wife. I think that the reason for setting aside a judgment is whether it is equitable, and it's not equitable for one spouse to be awarded all of the property without some finding that would justify such a 100-0 split. And because family law is premised on equity and property division, particularly on an equitable division, that should not have been entered as in light of equity.
Excuse me, Ms. Gill, but doesn't subsection 4 require that there be changed conditions? I think it talks about it's no longer equitable to apply it prospectively.
That is the provision in the reason 4, and it's a point well taken. So there, you may not want to see that as an issue of changed conditions of no longer being equitable, in which case I would submit to you that reason 5, it is not just for this order to be enforced, ought to apply to this issue of all the marital property being awarded to one spouse without any factual findings to support such an award.
Isn't that something that could have been appealed originally?
I believe so, Your Honor.
And section 5 is only for extraordinary circumstances. So if we were to follow that and your suggestion here, wouldn't we just be saying the time for appeal is really not very relevant because you can always bring a case under subsection 5 of 60B?
Subsection 5 is supposed to be for extreme conditions. I submit to you that this Rule 60B does address extreme situations in that the separation agreement and parenting plan, which were incorporated by the order, were not attached to the order. The separation agreement and parenting plan were never served on the husband in this case. And I think that that brings forward a due process concern that I think takes it outside of simply it should have been resolved with a direct appeal. My reasoning there is that the husband never knew about this separation agreement and parenting plan. He had submitted his own, which had different terms, which I submit to you were equitable, like a 50-50 split of equity in the marital home, week on, week off parenting plan, rather than having all of the parenting time with mother. So when the only separation agreement and parenting plan he was aware of was his own, I think that he was not on notice that the decree of divorce and the reference to a separation plan, or separation agreement and parenting plan should have put him on notice to appeal.
And counsel, would that then be the changed circumstance that would justify filing a 60B under subsection B4, making it not equitable?
I think that you can't.
The lack of notice.
The lack of notice, I think, could be the changed circumstance. I think the lack of notice is also an extreme circumstance under 5 reasoning.
And counsel, does the record show whether he was aware of the simplified separation agreement filed by wife within the time to appeal the dissolution decree?
What the record shows is that wife's separation agreement and the parenting plan was not served on anyone. It was filed in December. The decree was entered the following September. It was not until April of the following year that when wife filed her motion to vacate and set aside, in which she attached those documents, that's the first indication that those were served on husband.
All right, so he couldn't have appealed based on the simplified separation agreement anyways?
He had no notice of it.
Okay.
And that's the primary thrust of our argument.
Did husband file anything, or I don't think there were any hearings, but did husband file anything saying, I never was aware of this?
That was his response to wife's motion in April of 17, is that he wasn't aware of it, and he incorporated in his response to her motion his own request to set aside at that time. The trial court, in denying wife's motion, also said that a response to a motion should not incorporate a request for relief, so that was not addressed at that time.
I understand that the husband and wife continued, is it correct that they continued to reside together after the September order was issued by the court?
That is the information in the husband's filings, is that the couple continued to reside together full-time. There was one indication that he had gone on a vacation without her, but that he did live with her and the children in the same house throughout the course of this litigation. That's what's in the record.
I thought I saw a notice of address change that the wife filed at some point, like in October, but I can't recall the year, where she gave a different address.
Your Honor, I'm not remembering that.
I'm sorry, I can't give you a page. Yeah, notice of address change, page 241 of the record, and it's dated October 25th of 2017, so that would have been after the filing of the 60B motion. So not during the proceeding. So is that when they moved into separate homes?
I'm not aware of
Okay.
that. I don't have an answer for you.
But it seems like there may be a factual issue whether in fact he knew about it. If they lived together for a year after the order, and was he making payments? Did he make payments according to the order? throughout that
According
period?
to his filings in court, he continued to support the family as he had prior to the divorce. He paid the mortgage, the utilities, the groceries, etc. He did not make separate support payments. He just continued what had been in place prior to the dissolution filing of paying all expenses of the family.
Thank you.
I talked about two of the four issues in the Rule 60B motion. I'd like to continue. His third issue points out that there were no factual findings on the conflicting documents submitted to the trial court. Husband submitted his sworn financial statement indicating his first sworn financial showed a gross income of $3,801, which certainly should have been considered in awarding wife maintenance of $1,800 and child support of $1,800 for a total payment of $3,600, which simply is not feasible on a gross of $3,801. So that would be a due process. There should have been factual findings as to the conflicting information. That, once again, would be, I think, reason 5, extreme reason for setting aside the order. And the final issue was the lack of equity in awarding all parenting time to wife in this situation. I think that because these reasons do fit under either 4 or 5 of 60B, that this is a proper 60B 4 or 5 motion, and the court should have analyzed it in that manner. The motion itself, in addition to the caption, also quoted the entire rule and then proceeded to set forth how it fit these 4 issues and how they fit within 4 and 5. I think that that should be enough to trigger the time, within a reasonable time, for filing the motion. I submit to you that because a husband did not have notice of the separation agreement and parenting plan until wife's motion in April, that should be the trigger date for counting when is a reasonable time. He certainly couldn't have challenged it when he didn't know about it.
But just to be clear, it is certainly clear that he was not formally served. At least there's no certificate of service showing that he was ever formally served with it. But we do not know, as a matter of fact, there's no affidavits, no testimony indicating whether or not he had learned of it otherwise.
His verified response to wife's motion states he did not have notice.
Oh, that was verified? Okay, thank you.
Yes, it is verified. And several of his pleadings from April on in 2017 were verified, in which he objected as to the lack of notice of the terms of the separation agreement and the parenting plan. So I consider wife's motion to set aside to be the earliest that you should start counting the time to calculate a reasonable time. Husband did, in his response to wife's motion, request relief. The court said he had to file a different motion, but the court was going to deny it as time barred, as the court denied wife's motion as time barred. It also required the parties to participate in mediation. They did promptly participate in mediation after the trial court denied wife's motion. They filed the certificate of mediation. Then husband filed his motion, and the court denied it for failure to mediate. The husband requested reconsideration and attached the certificate of mediation again, and 3 days later, he filed the 60B motion that we are talking about today. That was a comparatively short period of time when you are looking at 4 and 5. I think that the 182-day time limitation for 1 and 2 is not applicable here. I would also submit to you that the rules of civil procedure are supposed to be construed liberally to achieve justice, and it is not just and fair to award spousal support and child support that almost touches a husband's total gross income. I'd like to reserve my remaining time for rebuttal.
You may.
Thank you.
Judge Ramon, and may it please the court, Mike Hoffman, registration number 30207 for appellee Norma Ramirez. The divorce decree was filed in this case on September 20th, 2016. This is the decree. It has on the second page of the form an express incorporation of the simplified separation agreement that Ms. Ramirez filed. It gives its name, it gives its date. The appellant admits that this order was served upon him. So if he read it, he had notice both that Ms. Ramirez had filed a separation agreement and date on which he filed it. In response to this order, the appellant did nothing. He didn't file a Rule 59 motion. He didn't appeal. He didn't file a timely Rule 60B motion. Instead, 395 days after this decree was entered, he filed a Rule 60B motion. Judge Laff denied that motion because it was untimely.
Well, let me ask you about that. Because the judge had said, had denied a 60B2 motion to your client and had said, and if the husband files, I'm paraphrasing, something similar, I'm going to bar it as time barred as well. So today, how do we know the basis of the judge's ruling, whether the judge had considered it as a 60B4 or 5, or whether the judge had said, basically, like I said earlier, if you file something, I'm going to find it barred under the 6-month rule?
I think there's 2 points I'd like to make in response to that, Your Honor. First, the judge, I think, knew what would be coming from the husband if the husband filed a Rule 60B motion, because in his response to the wife's motion, he raised a lot of his complaints about errors that he said the court had made, except for one. In his verified response to the wife's motion, he never says, this separation agreement wasn't served on me. That statement is not made in his response to the wife's motion. That comes up for the first time in his own 60B motion, the husband's own 60B motion, which I just looked, doesn't appear to be verified. So the idea that he wasn't served with the separation agreement, I think, was a late-breaking development. Second, I think there are 3 options here in terms of how Judge Laff handled the order. And I'm going to go in order from most plausible to totally implausible. Most plausibly, he looked at the substance of the motion, which is what he is supposed to do. The court's question asked whether or not the caption sort of forces him into a particular time limit. The answer is no. There's an Atlas construction case, 197 Colorado 66, and Brown Grain, 878 Pacific 2nd 157, which is a Colorado Court of Appeals decision, which say essentially you look at the substance of the motion and beyond the caption. So I think that's what Judge Laff did. I think he looked at the motion and saw it was all about error and mistake, and properly concluded this was a reason 1, I don't say subsection, I say reason 1 motion, and denied it as time barred. The second thing I think he might have done is he may have taken it at its word and said, okay, it's a Rule 4 or 5, I'm sorry, reason 4 or 5 motion, but then I think he would have understood that was not filed within a reasonable time. It was filed more than a year after the decree. It was filed 6 months after the wife filed her motion. It was filed 6 months after the husband had a lawyer.
But he doesn't say that, right, in his order?
He does not say this. He doesn't say that in his order, but in terms of understanding what he did, I think he may have done that. I think it's more likely he knew it was a reason 1 motion because of its multiple references to error in the motion, realized it was a reason 1 motion and denied it on that basis. It's interesting today, you didn't hear in the presentation from the husband the word error a single time, but it's all over the motion. What's being presented to this court is not what was being presented to Judge Laff. Now, the least plausible thing I think Judge Laff might have done, and I don't think he did this at all, is he may have said, well, it's a reason 4 or 5 motion, but I'm going to apply the reason 1 or 2 time limit. Now, that strikes me as wildly implausible. The rule is very clear. And to attribute that kind of mistake to Judge Laff on the basis of this record, I think would be inaccurate and inappropriate.
But instead of trying to speculate of why he might have done what he did and giving the 3 scenarios and trying to figure out which one it is, wouldn't it make more sense to remand it and have the trial court judge reconsider it at that point so we could understand why the judge did what he did?
No, I think this is a abuse of discretion. I think no matter which option you choose, I think there's no abuse of discretion, at least for the 2 plausible options. I think the rule is judicial decisions are presumed to be correct. There's a presumption of regularity. If this court can determine a basis in the record to affirm the judgment, I think that's what you do. And you do have a case here where a Rule 60B motion was filed more than a year after the underlying judgment. And it's extremely rare for the Colorado courts to ever find that that's timely. especially given the kind of delay that you have here. I mean, you heard about a reference to mediation. The mediation certificate was filed at the end of July of 17. This motion was filed at the end of October. It's a 4-month delay. That's a lot of time. And I think one of the areas, one of the issues that comes up under Rule 60 is there's a tendency to view the 182-day limit as sort of the minimum reasonable time. I don't think that's correct. It's the maximum reasonable time. It applies to things that are extremely serious and may justify setting aside a judgment. For example, fraud. You get 182 days for fraud. You don't get more than a year or 4 months because you didn't read the order or read a separation agreement that was expressly incorporated into the order. So I think the legality and the appropriateness of what Judge Laff did is evident from the records. I don't think there's any reason for a remand. One of the court's questions was whether or not the body of the motion, setting aside the caption, let me point out, just the caption is also sort of a mess. It talks about clarification or amendment pursuant to Rule 60B. It's not available pursuant to Rule 60B. Rule 60B simply allows relief from the operation of a judgment. So the caption itself, I think Judge Laff had a good reason to look past it, and I think it was appropriate and actually required by the law to look past it. You can't sort of smuggle in one ground under another ground. You say, I'm going to use the reason 4 time limit, now talk about reason 1. I mean, that strikes me as kind of a bait and switch, wouldn't be appropriate. But once he looked past the caption, there was nothing in the body of the motion that would have forced him to conclude this was really a reason 4 or 5 motion. Reasons 4 and 5 are not separately called out in the motion. There's just a block quote of Rule 60B. There is no discussion of the legal standards that govern reason 4 or 5 in that motion. Nothing at all. You can read that motion as a trial judge and not have any idea what standards you're being asked to apply if you're really being asked to apply reason 4 or 5. There is no application of the facts to those legal standards. And in some cases, the motion actually pleads itself out of reason 4 or 5. The motion, Judge Miller, you pointed this out, the motion talks about the order being unconscionable from the start. Under reason 4, that's a non-starter. Reason 4 requires changed circumstances to make it no longer equitable for the order to be enforced. That was emphatically not the husband's theory here. He said this was unconscionable from the start. With respect to reason 5, the long list of alleged judicial errors in that motion violate the requirement of reason 5 that you have to have some reason that's not covered by the prior 4 reasons to rely on reason 5. Errors and mistakes are covered by reason 1. So by relying on reason 1, the husband pled himself out of court on reason 5. Judge Laff properly saw past the caption to the substance of the motion. And by the way, even if you read the motion sort of for all it's worth, with the benefit of hindsight in the presentation on appeal, and you look for this issue about notice of the separation agreement, you're not going to find much. You're going to find a sentence, a subordinate clause at the end of a sentence, which asserts it wasn't served on the husband. But you see no development of that argument in the briefing below. Even if there were development, I think that would inevitably lead the husband back into the mistake grounds. What does he say? What he really says is, in April, when my wife, ex-wife, moved to set aside the order, I was surprised to see she had filed a separation agreement. That's really what he's saying. And surprise is covered by reason 1. And he says, I made a mistake not reading the order. Also covered by reason 1. You should excuse my neglect in not reading it and not appealing it. Also covered by reason 1. So everything in that motion is reason 1. And there is a suggestion on appeal that for some reason there's been a violation of due process. There's no violation of due process here. The husband was served. He was served with the order. The order incorporated the separation agreement. He had actual notice of it if he read it. He had constructive notice of it if he ignored it. Legally sufficient notice either way. terms
You
of,
say he had actual notice of the separation agreement?
oh, of course, yes, if he read the order, he would see that it is referenced, it's given its title, and it's given its date. To me, that is notice that there's something in that court file that he needs to go look at.
But he didn't have actual knowledge of the contents.
If he didn't, it's because he didn't read it. But I think notice and knowledge are two different things. I could have notice of what's in a contract as I sign it, but I haven't read it, so I may not have knowledge. But the law presumes a notice and sufficient notice to hold the person to what's in the agreement. And I would.
Is there any indication in the record that the ex-wife ever spoke to him about the separation agreement?
No, but there was a hearing in January of 2016 where the wife referred to papers that I filed. And the husband was at that hearing, and they both had an interpreter. And if he was there and if he was paying attention, that should have alerted him she had filed something.
Counsel, at that hearing, though, hadn't he also filed his separation agreement? So we had two separation agreements in the record, and the one he filed, she actually signed before she filed hers, right?
No, I don't believe so.
I think she actually signed his separation agreement in November, and then it was served on her with the certificate of service, and then she files her copy in December, and then he files his copy early January. So she was aware of the contents of his separation agreement when she went and filed hers.
I'm not aware that she signed his separation agreement. There's an indication that it was served on her. The husband signed it in October, served it on her in November of 15, and then filed it with the court in January. She had filed hers in December.
Right.
So I don't believe it's correct to say that she signed it. Nor,
But she received a copy of it in November before she filed hers.
That's correct. If the
Okay.
certificate of service, which says the husband hand-delivered it to her, is correct, and I have no reason to believe it's not, she would. Now, why she would sign his agreement, which gives her no child support, no maintenance, and only a little bit of the house, I would not understand. I don't think she did sign it. So, to answer your question, I think the husband did have notice that the wife had filed documents. Definitely when he got the order, he should have known and should have gone and looked at it. There is no excuse for his delay, and his motion, because it was based on reason one at the end of the day, was time barred under reason one of Rule 60B. Let me check my notes to see if I have anything else. Unless the court has questions.
Is there anything in the motion that couldn't have been raised in a direct appeal?
Nothing. Everything that was in that motion could have been raised in a direct appeal. Everything. Every error that the husband later complained about is apparent on the face of the order. So he could have appealed it at that time.
Well, not on the face of the order, but there was notice. You're
True,
saying.
true. There was notice of it, exactly. But yeah, there was nothing stopping, I apologize, there was nothing stopping the husband from taking an appeal at that point, filing a Rule 59, if he didn't think the order was appropriate, or even filing a timely Rule 60. What he can't do is wait more than a year. And I do want to make a point, I raised this in the brief. The husband acts as if Rule 60 can go back retroactively and undo what was done and relieve him of the obligations he had. That's not how Rule 60 works generally. That would be especially dangerous in domestic relations cases, where spouses are entitled to rely on the orders that the court enters unless and until they're modified. The statute that provides for modification says it's prospective only from the date the motion was filed. If the court starts letting people use Rule 60 to go back and upset what's been done and force spouses to give back the money, sell the clothes that have been purchased for the children, that would be a disaster in domestic relation cases. Judge Laff properly applied Rule 60 in this case. He read the substance of the motion, came to the right decision. His order should be affirmed. Unless there are questions. Thank you, Your Honors.
Opposing counsel tries to cast all of the argument in the 60B motion as fitting within reason one, mistake or error. Traditionally, that reason has been construed to refer to a mistake of the party. The 60B motion asserts errors by the court. not by a party. The 60B motion asserts a lack of due process in that he didn't get the separation agreement. Opposing counsel argues that he actually had notice of it. I submit to you that when these parties appeared in court, they both used interpreters. And to have a 2-page order that says you're divorced and I'm incorporating the separation agreement and parenting plan, identifies it by a date. As opposing counsel just said, the parties were back and forth with the documentation, and I think that if there was a mistake by a party, Mr. Ramirez certainly thought the only separation agreement he was aware of was the one that he had been working on for a couple months that he finally filed in the court in early January. I think that the substance of the motion goes well beyond the caption. There are the 4 issues presented in the motion, and that they are phrased in a manner that should trigger review under reasons 4 and 5 in this case. The trial court's denial of the motion was extremely brief. It's time barred for the reasons set forth in denial of wife's motion. I think that doesn't give you much to work with. You really don't understand why the court was doing what it did here on the facts it had in front of it. I would ask you to reverse the denial of the 60B motion and send it back to the trial court for consideration of what should go on here. As to opposing counsel's final point, he was talking about modification of support orders. That might be the effect here, but what is in place right now is a support order that was in place for over a year that is practically equal to the gross income of husband. That is inequitable, it's unfair, and this court has an opportunity to create some fairness and equity in this case. Thank you for your time.
Thank you, counsel. And thank you both for your really fine arguments. The case will stand submitted and an opinion will issue in due course. That concludes the division's docket for this morning. The court shall stand in recess and the bailiff may so announce.
All rise. Court will be in recess, subject to call.